Okay, good morning, everybody. Thank you very much for being here. This is the first seminar of a series of seminars called Comparing Constitutional Justice that Professor Christopher McCradden and myself have concocted, and involving our two institutions, the University of Macerata and Queen's University Belfast. To begin with, and I'll be very brief to avoid wasting time, allow me to thank all the participants for their patience and their collaboration for what was needed to organize all this. And I'm very heartily thankful to all of you for your cooperation in this. Just a few words about the inspiration that is underneath this seminar series. Well, to me, it would be a long story, but I do not want to have time to share with you this long story. The basic idea is that a few years back, when I was much younger, I had the opportunity to have a few meetings with Margaret Marshall, who at that time was the Chief Justice of the Massachusetts Judicial Supreme Court. We were in Boston, and it was a very, historical moment because she had drafted the majority opinion of a landmark case called Goodbridge versus Department of Public Health, a decision taken in favor of some same-sex couples that had been denied marriage licenses in the state of Massachusetts. That juncture was particularly meaningful because a bunch of courts in the United States, but not only, had ideally contributed to the dialogue that led to that decision and to the decision taken by the US Supreme Court a few months before then. And so I had the very good fortune of these meetings with Justice Marshall. We discussed about a great deal of issues, but also about the role of justices. And she told me the following words. Well, I'm paraphrasing because it was 2003 and memory doesn't serve me very well at this point. I'm aging at a very accelerated pace. But she told me the following words. Justices belong to the same community. Despite the differences of their jurisdictions, they belong to the same cultural common enterprise. The common cultural enterprise is literally quoted from what she shared with me. So this was the original inspiration for this series of seminars. Chris and I would like to offer our prestigious guests every year with different topics, a continuing forum for dialogue, for mutual understanding and learning, a forum in which they can share not only the secrets, but also the difficulties of their job and also their different perspectives. I teach comparative constitutional law, so my interest in this kind of events is, of course, natural. I think that's all I had to say in order to avoid wasting more time. The seminar will have this structure. The first part will see each of our justices presenting her own remarks for 10, at the most 12 minutes, and I'll be very strict about this because I've been asked to. Then we'll have a break, and after that, we'll have the precious contribution of our two discussants introducing the Q&A session with their remarks, and then we'll have a dialogue among all the guests, and of course, questions from the audience will be absolutely welcome. So thank you very much for being here. Thank you for your attention, and enjoy the morning. Thank you. We are going to leave the floor to our prestigious guest, distinguished guest, in strict alphabetical order. So the floor now is to Justice Rosalie Abella from the Supreme Court of Canada. I need to tell everybody that I won't indulge on the intimidating achievements of every of the justices seated here, because we have already uploaded their impressive list of achievements on the official web page of this event. So, Justice Abella, Rosie, the floor is yours. Thank you.
I want to start, since I'm the first of 6 extraordinary presenters, to thank Benedetta and Chris for the privilege of being able to be here with each other at the University of Macerata. I mean, we have known each other, most of us, for many years. Esther is our new best friend, our new BFF. But the collegiality, the shared experiences that we all have, I must say, to be able to share them with you here in Macerata is a great privilege. So thank you, Benedetta, for organizing it, and Chris, and thank you, Sonia, for the luminous performance yesterday of what the best of being a judge is. I think we were all inspired, all reinforced, and every one of you who was lucky enough to be there knows that it just doesn't get any better than Justice Sonia Sotomayor. So let's start. I thought, since I'm the first speaker, I would break this talk into 3 parts. The first is the historical evolution of women's rights in our lifetime. The second is some personal reflections on how I came into that arc of the moral female universe. And then finally, the experiences on the Supreme Court of Canada. All of this in 10 minutes. So I will talk quickly. But let me tell you first where we've come from, all of us in this generation. It used to be that the Anglo-American tradition was that women were, when they married, part of one personality, the husband. They had no rights, no property rights, no support rights. They are utterly, completely, economically, and socially dependent. I tell you that because that is the legal origin of all of the assumptions that we've been using as an albatross since. We overcame it in Canada in 1968 with the divorce law, and I have to tell you that when people couldn't divorce, they had no idea what the family law was. It was only when they were offered the possibility of leaving an unhappy marriage that they discovered, women, that the family law was against them economically down the road. So that was the revolution that took place in the 70s. We started having conversations about property laws dealing with family law. We also started to see women coming into the law schools. We started to see conversations about pay equity, childcare. So the 70s was the opening up and women going into law schools. When I graduated from law school, there were 3% of women in 1970 who were Canadian lawyers. Now it's over 40%. When I became a judge in 1976, 41 years ago, there were no other women on the family court bench. So it's extraordinary, the revolution. Now there are 37% judges who are women. So that's the historical arc. We came from having no rights to an explosion of rights in the 70s and 80s. Now let me tell you personally how I fit into this. And it's important for everybody to know that every single one of the 6 of us has a different narrative, different personal story. What is true of all of us, however, is that not one of us ever dreamed when we went to law school that we would end up on a Supreme Court of our country. Not one of us. So let me tell you why that was true for me. We came to Canada from Germany as Jewish refugees in 1950. My father had been a lawyer in Europe. He graduated in 1939. The war started the day he married my mother. He ended up in concentration camp with my mother, went to Germany after the war, learned English, practiced law, came to Canada, went to the Law Society and said, I can speak English. What test do I need to be able to practice law? They said, no test. You're not a citizen. You can't practice law. So I was 4. It's my first memory of Canada. That's the moment I decided to become a lawyer. I had no idea that women weren't lawyers. No one told me, because the 2 people I cared about most, my parents, thought there was no reason why I couldn't be a lawyer. By the time I graduated from law school and realized women weren't lawyers, it was too late. I'd already been fully formed. I didn't think there was anything women couldn't do. School was a merit system. If you worked hard, you got good marks. Suddenly I hit the culture, and the culture was that there were things women were supposed to do and things women didn't do. Because I had no ultimate goals, because I knew if I was just practicing law, that was the luckiest thing in the world for me. I had no objective against which to measure my career. So when they called and said, do you want to be a judge in 1976, when I was 29 and 7 months pregnant with my second child, I said, sure. And everybody said, are you crazy? This is the lowest court in the country. And I said, they want me to be a judge. I don't even know any judges. Of course I'm going to be a judge. I had a great litigating career, I have to tell you, and I found pregnancy to be an excellent advocacy tool. I never lost a case when I was pregnant. So I became a judge of the family court. This court, everybody said, forget about it. It's just not a good court. And I learned how to be a judge. Because what I learned on that court, to listen, to understand that the world is not my world, not a top-down world, that the experiences I had, the luck of being in a home with supportive parents who supported everything that I wanted to do, was not real life. And I never lost those lessons of being a family court judge. And because I wasn't going to end up on a Supreme Court, I said yes when they asked me to chair a labor board, even though I knew no labor law. I said yes to running a law reform commission. I said yes to teaching at a law school. I said yes to everything. And it was almost always controversial. And it didn't matter, because what was it going to do? Stop me from being a Supreme Court judge, which I was never going to be? So I found myself anyway on the Court of Appeal with 3 other women. Now I'm on the Supreme Court of Canada. How that happened, I have no idea. But here we are now on the Supreme Court of Canada. We have had 9 women on the Supreme Court of Canada. Our first was in 1981, at the same time that Sandra Day O'Connor became the first woman. It makes a difference when your first woman is spectacular, and she was spectacular. And so she normalized the possibility of women being on the Supreme Court. She was a feminist. She had a Chief Justice who was a male, also a feminist. The 2 of them together choreographed the Charter of Rights and Freedoms, which we got in 1981. I called them the Fred and Ginger of the Charter of Rights and Freedoms. And they set the tone for the future. We ended up with women, all of whom were very rights-oriented. We never went through on the Supreme Court the phase of who do they think they are? Do we really want feminists on the court? And remember that it takes 5 to be a majority. The women couldn't do it without the men. So there was cross-pollination of ideas. The women introduced men to concepts they hadn't known or implemented before. And now with 4 women, including a Chief Justice who's a woman, what happens at the court? Well, there's a real emphasis on collegiality. It matters to us. And we're the language police. And we say to colleagues, do you really want to use that tone? And colleagues are very, very responsive. And we do something else that's really quite amazing. The first time it happened, there was a male colleague in the room who couldn't believe what he was hearing. We were discussing a provision of the criminal code. And the conversation, 2 women and 1 man. And the conversation went like this. I don't think that's what Section 20 was really meant to do, because after all, you're dealing with a long line of jurisprudence. I love your necklace that says that the seamless way the brain, the female, the fact that nobody was embarrassed about the fact that we were women, and we were judges, and we were cerebral, and we were jurists. So let me wrap up with what I've learned from all of that. I've learned that it is as important to be true to who you are as a woman as it is to be able to build alliances with men who are also feminists. I have learned that judicial neutrality is not about not having views. It's about knowing that you have views and being open in spite of them. I've learned that it's not just what you stand for, it's what you stand up for. I've learned that indifference is injustice's incubator, and that we can never forget how the world looks to those who are vulnerable. So let me close with this story. Those are the lessons that came from someone who was fortunate enough to experience so many levels of the law, because I never aspired to anything except appreciating and immersing myself in the life of the law. But when you take steps that feel right, history has a funny way of coming back to reward you. One of the things that I agreed to do was a royal commission on equality in employment. The government wanted to know how to eliminate barriers for women, Aboriginal people, persons with disabilities, and non-whites in the workplace. I was a one-person, 1 year, $1 million royal commission. I had a sense that there may not have been 100% appetite for it, because there was, at the same time, a 7-person, 4-year, several $million study on baby seals. Anyway, I went ahead. My biggest task was to define equality. There had been no definition of equality except the American definition under the 14th Amendment. That definition was, it is treating everyone the same, treating likes alike. It struck me that that was like Anatole France's aphorism, the rich and the poor have an equal right to sleep under bridges and steal bread. And so I reconceived the notion of equality in a way that, after listening to people across Canada in those 4 groups for a year, struck me that you can't have equality unless you acknowledge and accommodate people's differences, accept who they are so that they can integrate as who they are, instead of pretending that they can assimilate. The first time the Supreme Court of Canada decided equality rights under our Charter of Freedoms was in 1989, 5 years after my report. And the first case was a case about a lawyer who wasn't a citizen and wanted to practice law in Canada and couldn't because he had to be a citizen. And the Supreme Court used my definition of equality to define equality in Canada and strike down the citizenship requirement that had kept my father from practicing law all those years ago. He died a month before I finished law school. But I have to tell you, knowing that my words were used in a way to create equality retrospectively for him and for thousands of others, was probably where my career could happily have ended. So I didn't start planning to do that. I didn't start planning to do anything except start a conversation about equality. It came from who I was. I ended up, like all of these 5 wonderful women, on a Supreme Court, and I have never stopped believing in all of the things that I believed in when I went to law school in 1967, and they have all proven to be right. So if you live long enough, your dreams may in fact come true. So I wish you all success, and thank you for including me in this program.
Well, thank you very much, Rosie. Thank you very much for all that. And now it's the turn of Susanne Bayer from the German Bundesverfassungsgericht, which is the Federal Constitutional Court in Germany. Thank you very much for being here.
Thank you for the invitation. Thank you for your curiosity that day. And I think after Rosie Bella's remarks, you know why it's hard to speak after her. I could listen for another hour to what she has to say, and that is the same true as well for all the others. So let me still, oblige to the invitation and use my time to share my perspective with you on being a justice on the German Federal Constitutional Court. And I want to split it in 3 remarks. One is, how do you get there? Who are you when you're there, and what can you do once you are on that bench? In Germany, the way you get there is by way of election, which is different from many other countries. We are elected by parliament or state governments, and we are proposed by political parties because the creators, the designers of that constitutionalism thought it's a good idea that people know where you're coming from in terms of ideology or perspective on life, which means a little more conservative, a little more progressive. They were also smart enough to design the Constitutional Court as a limited period in your life, which is 12 years of service, which I think is a long and good period of time, but it also allows for the court to renew itself periodically, which is important, and it also created a system where the political parties can, go for their preference, send a lefty or send a conservative, but not send ever an extremist, because you need a 2/3 majority in parliament to have them elected. So why in the world did they think of me, and why did I make it in elections? Because when I got that famous phone call, and in fact these are famous phone calls, and was asked whether I would, start a conversation on the open seat for the Green Party, which is a small ecological, civil rights, feminist, lefty party in Germany. If I would like to discuss that open seat, I happily said yes and suggested 3 names of eminent law professors who I thought would be suited for that position. And then they laughed and said, that's only women who do that. We thought of you. I'm like, you're kidding. Why? One part of me was thinking, you're kidding. The other part was a little bit afraid. Because in my former or other life, I'm an academic, I'm a law professor, I teach students. But I did so as a gender studies and law professor, known as a radical feminist, which in Germany, I think maybe also in Italy and in many other countries, is not really the qualification attached to Supreme Court justices. So radical feminism, and in addition to that, openly gay or lesbian. I thought, that's not going to fly. I thought they're not going to vote me in. I thought with a 2/3 requirement and a conservative majority in parliament, they're not going to be totally excited to have me on that court for another 12 years with a lot of power in your hands. The positions we have in our countries are very powerful positions. Okay, so I said, if they ask me, I should say yes. I never expected that. I never dreamed of it. But you should say yes when you are asked, and people trust you and people think you would do a good job there. So election went and, they voted me in. So then I arrived thus as a radical feminist. The paper said Miss Professor Unusual, whatever that means, or Coloring the Republic, whatever that means. Or some said, partnered with a woman and out in the open, whatever that means to people. So I arrived, and in addition, I also arrived as a comparative constitutional scholar, which is another part of my identity, and as a committed European by way of family. I was born near the French border. I enjoyed traveling across Europe. I am so European, whatever. As a German, you prefer to be European when you're part of my generation and not German. But Europe was also part of my identity. So arriving on that bench as a woman was certainly being a woman on that bench, but also being much, much more always. As gender studies tells us, you're never only female in these positions, you're always somewhat female because people read you as a woman, but you're also always a modification of the woman on the court. So I was the radical feminist, lesbian, European comparativist woman on the bench, you know. And sometimes it so happens that I'm reduced to the woman or the only homosexual in the world. And that's a challenge and a task and a problem sometimes even, because all my work in my life as a feminist, as part of these movements, was not to ever be reduced to only one identity. So all I care for and stand for and work towards was not to be reduced to the woman, the lesbian, the whatever. So now I'm there as the example, the figure out there, the lead character in the play. What do you do? And I join Rosie Abella's call for, you're not only there, you have to be out and about it. You have to speak up. Mere presence on a court as a woman, as a whatever you're labeled as, is not enough to do the work. So when you're there as the one you are, what do? What I think you do is you speak up. You do not evade any discussion. You do not forget where you come from. You do not think, okay, I made it, finally I'm here, now I can be a justice. In pure rational legal neutrality, delivering, the judgments in this manner of, in my red robe, etc., etc. What you do is you stay true to who sent you there, who asked you, who gave you that phone call, and who you are and who you're committed to in the world, which in my case is the women's movement, LGBTIQ, etc., people, civil rights committed people, Europeans, comparativists, human rights fans. So that's what I try to do, which means that sometimes you get on the nerves of your colleagues or your audience. Because when I went to the court, I promised to myself, I'm not going to deliver a single speech, whatever the topic is, where I'm not going to mention feminism, women's rights, lesbians, homosexuality, human rights, diversity, non-discrimination. So now figure out what the speech is like on, say, the court system in Europe. I'll include it, be sure. The point is, for my being a constitutional justice in my country, it was very important in a country, European-style court, legalistic, academic, bureaucratic style, some scholars call it, to still be committed to my life, my political background, the civil rights struggles I was involved in, and not pretend that this is not part of who I am on that bench, to include it in my professional being. So there are three, by the way, and this is the end of my remark, there are three ways of how I try to do that. One is outside of the court, speeches, lectures, teaching, whatever we can do with that amount of time we have left beyond the file work. So I try to be open about these issues, I try to make a point, I try to make people see that somebody like me can still be a constitutional judge, as diverse as others, and contribute to the larger calling of human rights, fundamental rights, democracy for all. So I do that outside of the court as a justice in the world. The second one is I do it in the court as an institution, which is yet not judging, but in the court as an institution, as somebody talking to my colleagues, opening their eyes to experiences they do not share, as they do for me. I engage in conversations with my colleagues and learn a lot from them, as much as I do hope they learn from me. And this is an important part of being a woman or whoever you are on a bench, engaging with your colleague, answering their questions, opening an insight into a different type of life I lived in my lifetime, and share and broaden their perspectives on what's out there. I also do try to bring my commitments to the institution in terms of staff, in terms of my clerks, in terms of mentoring young talented people wherever they're from, in terms of implementing non-discrimination in the institution as a work site. And then maybe most importantly for the world out there, I try to bring my life, my commitments, my political background, my community, my human rights struggle, my Europeanness, all of this to judging. Now, my contribution has to end because there's secrecy in deliberations. So I cannot tell you a lot about how exactly this happens. What one could say, however, is that it is important, at least in my experience, when you face a case, say terrorism, fighting terrorism, police data collection, which are cases the German Federal Constitutional Court is famous for, adjudicating again and again and again, reminding the legislature that there is a privacy right even under the pressure of terrorism. Is there feminism in that case? Is there critical thinking in that case? Yes, there is. Because there's racial profiling in data collection. Because there's stereotyping in policing. Because there is a need to pay attention to the particularities of diverse lifestyles, life experiences of discrimination in society in all matters we have in the court. So I try to bring, even in judging, my experience, my commitment as a woman my way, a woman your way, a woman whatever way, to judging in all cases I have in front of me. I think it is somewhat easier in the German Federal Constitutional Court than in some other courts in the world, because before I came there, the court had already gotten substantive equality. The court has already had a doctrine of interpreting equality in a substantive way as a strong right against discrimination. It may be easy for you to imagine why the German court made a particular point in being very strong about that after 1945, to say never again to exclusion of people because of their race, creed, background, religion, etc., etc. I'm not saying we deliver on every count, but I'm saying I joined a court which already had a commitment to substantive equality, which I shared in my life and try to further and deepen and sustain and bring to every case I can think of. I think that's the way I try to do it, but it's a small contribution, and there are many others here. And that's the ideas, empowerment, commitment to what you do. And I hope you do that in your future. Thank you for listening.
Thank you very much, Susanne. Thank you. And now the floor goes to Daphne Barak-Erez, who is Justice of the Supreme Court of Israel. Thank you very much, Daphne, for being here today.
Thank you. I'm so glad and honored to be here, and also inspired by my colleagues on this panel. When I started to think, what does it mean to think of being a constitutional justice or a women justice in general, I tried to first figure for myself what may be the purpose of thinking of appointing a woman judge rather than only a professional judge. And there may be a few answers, that some of them are already connected, I think, to themes that were mentioned. First, there is the simple purpose of equal opportunities, the issue that was mentioned by Rosalie, who addressed the generations where women were precluded from this opportunity. Second, there is the issue of creating role models. But third, and this may be the point that I will try to concentrate on, is the goal of bringing the life experience of women into judging. And I think this is very important, not only where the court has to deal with questions that are obviously questions of equality. Sometimes it's even more important when we when we have to deal with dilemmas of criminal law, family law, immigration law, and the question is, in what sense and in what way our life experience as women is relevant to what we do and how we think of some of these questions. And this is what I'm going to concentrate on. But before that, because I really feel that I also have to address and connect what I say to the very important things that were already said, I must say that to some extent, in my generation, part of the challenge is to explain why thinking of this issue of women judges is still relevant. Because when I went to law school, not that everything was great, but I started law school in '83. At that time, women were already judges in Israel. In fact, the first woman judge in Israel was appointed back in 1948, in the first year of independence. So national independence went hand in hand with first appointing women judges. And the first woman was appointed to the Israeli Supreme Court in the late 70s. And therefore, when I studied law, part of the challenge was to maintain the understanding that even though we have these happy facts, many things are still not okay. And when even these days issues of appointments to the Israeli Supreme Court are being dealt, it's still important to convince people that it is still an issue despite these formal facts. And I believe that this is still an issue. And part of the question is how to convince that this is still an issue when we have these forms of formal achievements. I can even share with you maybe a personal and maybe funny story, but that may give you another perspective on the same issue. That I have two sons, not girls, which is relevant to the story. And when they were in kindergarten, maybe the beginning of elementary school, they heard from someone that I'm a feminist. And they wanted to understand what does this mean. And they heard somehow that being a feminist is to care about rights of girls. So they approached me and asked me, "Mommy, why don't you care about rights of boys?" And I think that, I mean, it's a story of small kids, but I think that if we want to take this question seriously, it's important. When I used to teach law before I was appointed to the court, I used to be a law professor for many years and also taught gender law, among other things. And it was important at the time to explain to students that this is still an issue, even though maybe in the happy days of law school, they don't quite understand this. They start to be exposed usually to such issues when they enter the employment market and enter real life, when they go outside the merit system of the university. So, after saying these initial comments, I'll say that what I really believe is important, or what is our goal, is to bring the life experience of women to judging. And here we are confronted by another problem or another challenge, because sometimes we are justly confronted with the question, who are you to bring life experience of women? I mean, you're an educated woman, you already lived a relatively convenient life. When I was appointed to the Supreme Court, so I remember some of the headlines, you know, the liberal human rights professor from Tel Aviv University. So what does it mean? To what extent can I represent not only my own life experience, but also life experience of other women, which is the challenge. I think that we can do that, but it's an effort and it's a burden. I believe that each one of us brings to her position not only her personal life experience that maybe started only when she was born, but also we carry in our heads, in our minds, in our hearts, also the life experience of other women, the life experience of our mothers, of our grandmothers. Rosalie shared a very personal story. I think that, you know, in my head, I also carry the life experiences of my grandmothers who did not have the opportunity to study, you know, in these small towns in Poland where they were born. They came also to Israel as immigrants coming from Europe. So even if it's not our own personal life story in the narrow sense, this is also part of our life, part of our exposure, and part of our story in the broad sense. So when I'm confronted with cases, I try to bring into to the deliberation process not only my own life story in the very narrow sense. We don't have much time, but maybe just as a way of, you know, sharing very small human stories from cases without getting into the legal aspects of them. For example, I found this very relevant to dealing with cases in immigration law. For example, just a very short story. We have in Israel, as part of our immigration policy, the rule that if a foreigner is married to an Israeli, so they start a naturalization process. Well, this is very common. But if the Israeli partner dies in the middle of the process, the Ministry of Interior has to decide whether to go on with the process, and they have a test. They have to see whether the attachment of the foreign partner to Israel at that point is already significant enough or even more significant to the background connection to the country of origin. So we had a case of a woman who came from the Ukraine, and her partner died in the middle of the process, and she was interviewed in the Ministry of Interior. And how did the interview look like? She was asked, do you have family in the Ukraine? And she said, yes. Do you have property there? Yes. Do you have friends there? Yes. And what was the very surprising result? The result was that she has very significant connections to the Ukraine, and therefore she has to go back there. And when the case came to us, I thought that the wrong part in how this process was conducted is that they never asked her about her relations to Israel. So she had the opportunity, if she wanted, to offer other facts. But the question is, what is her life experience as a woman immigrant in Israel? Could she understand that she could offer other, may I say, alternative facts, but in a different sense, other facts that are relevant to the story. So I thought that we should really connect to her understanding, to her life experience in how to engage in that interview. Do I have the time for maybe another small story? Also, 2 minutes. Another story of immigration coming from the former USSR. You should know that Israel is also a country of immigration for people who come from all over the world. So another story of a person who was not originally Jewish, but her non-Jewish mother married a Jewish person, and they decided that he will be adopted by the Jewish partner of his mother, and he went to the big city in Uzbekistan and changed the name of the boy, and that boy grew up as the son of that Jewish person. When they tried to immigrate to Israel, they claimed that he's the son of a Jew and therefore can enjoy special immigration rights. The authorities started to check the papers, and they discovered that the adoption process was never completed. The name was changed. He grew up as the son of that person, but he was not formally adopted. So what did the Ministry of Interior say? Well, he's not the son. The adoption process is not completed. Now the question is, what kind of life experience should we apply when we assess such a decision? Or what could his mother 30 years ago in Uzbekistan could do to make sure whether the adoption process was completed. So maybe I don't have the time for more stories, but and not all the details are that important, but I'm trying to connect it to what I started with. What is important, I think, for us is try to import our life experience in the broad sense of the word into what we're doing, and not necessarily when we do equality law in the narrow sense of the word. And good luck to all of you, of course.
Thank you, Daphne. Thank you very much. And now I leave the floor to Marta Cartabia, who is Justice of the Italian Constitutional Court. Thank you very much for being
Thank you,
here.
Benedetta. Thank you very much. Sorry. I think I will stand because I learned something yesterday from Sonia, that when we have the opportunity to speak in public, it's not only the possibility of saying something to a number of people, but to speak to somebody. And since from this perspective I can speak only to half of the audience, I'd rather stand just to speak to everybody else because I cannot see the faces of other people. So I'm following her example. I'm trying to imitating her, but I will not try to be Sonia Sotomayor. Exactly. So I'm also saying a few words, and I will speak them in 3 short sets of remarks. The first one is about my personal experience in the context of the Italian Constitutional Law Court. The second one is about, is there a specific contribution of women to constitutional adjudication? And the third one is the question, why parity or genders matters in a constitutional court. But let me start with some remarks from my personal experience. Before being appointed in 2011 a member of the Italian Constitutional Court, I was simply an academic constitutional law scholar. And as an academic based in Milan and with some international experiences, mainly European experiences. And as an academic, I have to confess that I've never been that much engaged in gender issues. Okay, equality is one of the topics that interests people in constitutional law. Gender is a topic. I've written a couple of articles about that, the role of women in the Italian constitution and so on and so forth. But my focus was on other issues: Europe, human rights, religious freedom, separation of power, and all the rest. Then, 2011, unexpectedly, I was appointed at the Constitutional Court. And I arrived at the court as the third woman in the court, but the only one at that moment. The 2 previous ones, always one at a time, have been women in the Italian Constitutional Court. Now we are the 3 of us. Silvana was here, Daria has not been here, but anyway, we are the 3 of us, and it makes a huge difference. Being the only woman is an exception. Being one of the women is normal to be, even if we are just 3 out of 15 members. But what was the context of my first 3 years at the court? All the other 14 members of the court were men, over 70s, with mainly a lot of academic and also, let's say, experience in the government as counselor, or maybe with some previous appointments in the government. And that meant that when I arrived there, I felt a complete anomaly under many respects. I was the only woman, I was 48. I came from the north of Italy, the only one. I had only pure academic experience. I was interested more in international and comparative perspective than my colleagues. And so my feeling was really a shock being there. A shock because I felt for my first time ever that I was a minority. In my previous academic life, being a woman was not an issue. I mean, in academic, we have so many students in law school, so many women teaching in the law schools. In Milan, it is not an issue. With my husband, the issue of parity has never been a problem. We share all the task in the family and work life. So it was really, really a new life that was starting. And I became, little by little, sensitive to the problem of being a woman in the court because of that experience. So my first point, I can tell you something, and then I started understanding why it was like that, the Italian Constitutional Court, and we can have a number of historical reasons. Let's consider, for example, that in Italy, until 1963, there was a legislative ban to be appointed in the judiciary, not only in the Constitutional Court. This means that for the first 15 years of the Republic, with the new Constitution, there was still a piece of legislation prohibiting, from the legislative point of view, to women to be part of the judiciary. So this is really very telling about the context. That it is no surprise that in Italy you have a constitutional court where the large majority of justices have been men. We have just 5 women in 60 years of story of the Constitutional Court. We have never had a Chief Justice women in the Constitutional Court, but not even in the other Supreme Court, Court of Cassazione, Conseil d'État, and all the rest. No, the top position has never been given to women. But this is the history of Italy. I don't want to indulge too much on this point, but from the personal point of view, it was a shock, an interesting shock, that maybe can account for the different position that I have in front of these issues compared to those of my distinguished colleagues. For me, it was not that much to bring a problem of bringing a gender perspective in the court, but much more to learn how to be a woman in the court, to be myself. Because when I was appointed by the President of the Republic, Napolitano, and by the way, notice that 4 out of 5 women appointed at the Italian Constitutional Court have been appointed by the President of the Republic, because we have a mixed system where 5 judges, 5 justices are elected by the parliament, and the only woman elected in 60 years was Silvana Sciarra, only one. 5 are elected by the judiciary, and no woman has never been elected by the judiciary so far. 4 women, the other 4 women have been appointed by the President of the Republic. That means that this is a component very inclined to balance the composition of the court. When he invited me for a conversation, and it was just at the end of the summer of 2011, and he was proposing me this unexpected change in my life. He was well aware of what he was doing. I'm not really revealing any secret, but in this conversation, he said, I know that you are 48, very young for the standard of the Constitutional Court. I know that you have family, you have 3 kids, you are based in Milan. I know that you are a constitutional lawyer, distinguished and well, with a good reputation about your European studies. I know that you are a woman. I know that you are a religious person. And for all this reason, I would like you to be in the Constitutional Court. So that conversation was a very relevant point for me, because it was, the way that I started, I put my place in this new, different, completely with a majority of people that were so different from me, but it was, as I want you because you are all of this. And for me, so far, has been a learning process of being myself little by little, even in the way I dress, to be myself, not to be dressed like a man. It's a progress, that you learn to be yourself in a context where everybody else is so different from yourself. In these 6 years at the court, am I able to say that there is a specific contribution of women, not just myself, but also the other women that are on the court, to the constitutional adjudication? Well, I'm not sure about that. And I also want to start with a small story. Last year, I visited the Constitutional Tribunal of Chile, and the first person I met was Marisol Peña, the first woman in the Constitutional Tribunal of that country, the first Chief Justice of that country, being a woman. And she told me that a few years before, she met one of my colleagues, one of the best, I don't tell the name because I know we are recorded, so I don't want to speak about other people, but it was one of the best scholars ever in the constitutional fields of Italian studies, a Chief Justice of the Constitutional Court, a very progressive, open-minded person. When he met this woman, he says, oh, okay, you are the first woman in the court. That's fantastic. So you can deal with family law, minors, children, and all the rest. And we were laughing because this is the image that even the more open-minded people have about the women's contribution to constitutional adjudication. And this is a tricky question, because it is true that on this issue, I can tell you also some story. 3 minutes, okay, we are running out of time. We have something to say about this issue. I don't want to say that the presence of women does not make any difference about these issues. It's not true. I remember some decision of the Italian court on adoption cases where some remarks of mine make my colleagues think about a different solution of the case. But it is not only that. We have a system based on the juge rapporteur, meaning that there is a person out of the 15 judges that has the charge and the responsibility of making proposal to the court and writing the opinion of the court. And I've been judge rapporteur in many different issues: law and economics, competition, criminal law, prisons conditions, separation of power, federalism, healthcare, whatever you want. I cannot tell you that being a woman on the court is only on family issues that makes a difference. I'm not even able to single out what is my specific contribution to all these other matters. I can tell you that the difference of points of view, and this is my last point, is the more important thing. We can have, this is the third set of remarks, I will go very quickly, maybe we have the possibility of going back in later in the conversation. There are many reasons for having women in the court. The basic one is that it is a matter of simple equality. Women are in the society, why not in the court? Why not? Not why should we have women, why not? And my question is. But reflecting on this experience of my first 6 years at the court, I would say that it is a matter of richness and better adjudication. Because it is true what I don't remember who of my colleagues said, that being neutral is not having a point of view, but, okay, Rosie, I think that all of us bring all our experience. Yesterday we were talking about the personal and the professional. When a judge is taking a decision, is part of a group of people taking important decision about the constitutionality of legislation, brings all his previous experience as an academic, as a lawyer, as a previous judge, as a mother, as a rich, as a poor, as a learned person, as a religious, non-religious, open to the international context or not. Everything of our personality is engaged in adjudication. And this is very, very important, because I really think that the core of the deliberation of a court is to be open to the largest numbers of points of view. We have some basic principle in all our constitutional and judiciary in general, which is audit et altera pars. Listen to other people. Be careful to the parties, but also to our clerks, to our colleagues. My feeling is that reality and the understanding of what we have to decide became clear under the different doxa, the different point of view that each of us brings to the court. It's not by chance that our work is called jurisprudence, where the main virtue included in the word is prudence. And prudence does not mean that a lack of courage or a caution attitude towards decision. Prudence in the iconography is represented as with a number of faces looking back, looking in front, looking in the future. The iconography of prudence is a matter of gazes that goes everywhere. This is my feeling, that the more important virtue for being a judge is prudence, being able to look, to take into consideration all the data, the factors, the points of view, and having in the college of the judges that have to take decisions so important for the country as the constitutional decisions are, it's important to have women because it's simply another way to have a richer, a largest diversity on the bench, which is the most important feature for a neutral, impartial judiciary. Thank you very much.
Thank you very much. Thank you very much. And now it's the turn of Esther Kitimbo Kisakye. She is a justice from the Supreme Court of Uganda. We are very pleased that you're here with us, and the floor is yours.
Okay. I also take a leave, the same experience as Justice Sotomayor, and deliver my remarks standing. I think I'll move to the end. Let me use the podium. Can you hear me? Yes. Okay, sorry. It's a great pleasure to be here this morning and to be able to address you on my experience. Good morning, all of you. I want to begin my remarks by thanking our convener, Professor Babisan, and also the rector of this university for having deemed it fit to convene this important seminar, and also for bringing us together. For me, it has been a very, very important meeting because I've had an opportunity for the first time to meet my peers and very senior peers, and that is a direct benefit to me. So thank you very much, Professor Babisan. And of course, that also goes for the co-conveners from the Queen's University. Secondly, I thought I'm going to make some quick remarks. When I thought about this topic, one of the issues that came to my mind was, when we talk about constitutional justice, what do we mean? That's something that I can't go into in the 10 minutes that I have, but I thought it's important that we address this in our respective jurisdictions. In the context of Uganda, constitutional justice, reflecting on this topic, brought to my mind the various ways in which, the framework within which we deliver constitutional justice in the country. Of course, this is provided for by our Constitution, and I just want to very briefly highlight how this framework works. We have a constitutional court which is tasked with the responsibility of interpreting the Constitution. Now, appeals lie from that court to the Supreme Court. So in a sense, my court is the appellate constitutional court in Uganda. But besides the role of interpretation, we have other, like the courts enforcing the Constitution. And the Supreme Court, in this sense, hears the second appeals arising from matters which originated in our High Court. And these matters can be of a civil nature, they can be of a criminal nature, but eventually they end up in our court if the parties so wish, and we have the final say. In terms of election matters, the Supreme Court has original jurisdiction to hear petitions arising out of presidential elections. We hear and decide these matters as a final court. And the other aspect I also wanted to highlight is that in our Constitution, we have built in a provision for judicial review of administrative decisions. Again, out of those proceedings, usually which originate in the High Court, we hear appeals which may emanate from those decisions to the Court of Appeal and finally to our court. And lastly, we have a special procedure for directly enforcing human rights. And again, under that system, a party can go to court, to the High Court, challenging particular actions of the government and seeking for enforcement of their rights. I thought I would give that background because I'm sure many of you don't have that. Uganda is not one of the countries that probably you've had an opportunity to learn about. Now, proceeding from there, I thought I would then share my own experience or perspective as a member of the court. I was appointed a Justice of the Supreme Court in 2009, and I'm almost making 8 years on the Supreme Court. Now, listening to my sisters on the panel, I've learned something very interesting because I have colleagues who have similar experiences. I had never served as a justice before in any court. I was directly appointed to our Supreme Court, and I was also 49 years old when I was appointed. So you have a sister, similar experience as myself. But prior to my training, I had 27 years of having done it all. I was an academician, I was a practitioner of law, I was an activist, I had organized in the grassroots community and through civil society organizations. I'd done consultancy. So in my 27 years, I'd also worked in the corporate world. So I came to the court with a lot of diverse experience in areas of the law and also in areas of advocacy and human rights and research. So that was my training. And talking about appointments, our judicial appointment process is by nomination of the Judicial Service Commission, which makes recommendations to the president. But again, similar to my sister from Italy, when the president appointed me to the Supreme Court on our swearing-in ceremony, he also made very interesting remarks because he said, I actually didn't know Dr. Kisache. He was addressing. He said he didn't know me personally. But of course he had had the recommendation, and he read my resume. And he said, when I read her resume, I said, this is the right person to appoint to the court. And that resume, of course, reflected all this diverse experience that had been, and the work that I'd been doing. So, which gave me assurance because that was a reaffirmation that, yes, I'm going to the court. I may be young, but this experience is valued at the court. Now, I arrived at the court 10 or so years earlier than the usual time people get appointed to the court. And I made the decision, first of all, not having served as a judge, and secondly, being the youngest baby judge in terms of appointment, but also baby judge in terms of age, I said, let me lie low. Let me take time to take this in and to get, to know the business of judging. And I did that. So for the first 2 to 3 years, I was learning and seeking, taking guidance from my colleagues who, are much more older in terms of age and in terms of their judicial experience. But 3 or so years down the road, as I looked at our draft judgments, I was reawakened because sometimes you'd read draft judgments and you were like, some things are not right. And initially I thought like, maybe I missed it. So you go back and start reading over again and you're like, wait a minute, whatever I'm looking for is not in this judgment. And I recall, of course, initially timidly going, because when I was appointed, it was 3 of us, 2 ladies and one gentleman. So I sort of related more to my colleagues who had been appointed with. The lady was much older. She had been elevated from the Constitutional Court, Court of Appeal, and she was much older. But I related more to the gentleman, and I remember one decision going to him and saying, did you read that judgment? And said, yes. Did you find anything interesting? I mean, like, what did you find? I said, oh, I've already concurred with, I already gave back my views. Now, the problem in that draft judgment, in my view, we had not decided the case. And I'm like, do you know that there's no decision? And the colleague says, what? And he says, I said, look at it again. There's no decision. The issue that brought the parties to this court has not been decided. And said, oh, but I've already concurred. Now I can't withdraw my concurrence. So, and the other thing he told me was very interesting because he said, when those senior colleagues write their decisions, you think they know it all. And I'm like, oh, okay. So that was a learning experience for me. Then I was like saying, okay, I'm going to defer to my senior colleagues, but it was reawakening for me because I was like, I have to rely on myself. Okay, I have to trust my instinct. I'm going to respect my senior colleague, my experienced colleagues, but at the end of the day, I must make decisions as an individual justice. And if that decision agrees, if I agree with my other colleagues, so be it. If I am not able to agree with my other colleagues and we are not able to reach an agreement, then I'll put my judgment down. So, so in the second part of I told you it's about 8 years. So that now led me to another very interesting phase because when I would write my judgments, my colleagues agreed with me. But when they would generate their judgments, then in most cases I would agree with them, but then occasionally, you were like, no, there is something here I need to address. Now, the modalities of how we would address this were not as well defined in our court, unfortunately. In another situation where I had to raise an issue where the Chief Justice had written the judgment, I remember again going to another colleague and saying, I've written this memo. Do you think, we need to? And he was like, okay, yeah, let's share it. But I began to realize that as I became more bold with my judgment, in some cases, my colleagues agreed with me. In some other cases, their minds would be made up and they would not. And I decided to be true to myself. That's the position I've taken since serving on the court. I've earned myself a title of dissenter because I think I've written the highest number of dissents on my court. But in writing these dissents, in addition to some of the explanations that Justice Sotomayor shared yesterday about writing for the parties and knowing that somebody has heard you, for me, the other reason has been that we need to be true to the country and to the parties. If we can't genuinely reach an agreement, that's the position of the court. We should not, I respect collegiality, but at the same time, I've taken the decision that if the court cannot agree, if it is, we are supposed to sit 7 of us in constitutional matters and 5 of us in civil or criminal appeals, that's the position of the court. And maybe I'm right, maybe the majority are right, but we owe it to the public, to the country, to present these views so that the litigating public, the lawyers, the parties can take those views and refine them and bring them back to our court so that we can have an opportunity to again to look at this issue in another sense and hopefully arrive at some consensus. So I have, my conscience has been clear about this, and in approaching my work, I have decided that there are some guiding principles that have helped me in doing the work that I've been doing. One, of course, I've always remained, I am a woman at the court, But in approaching my work, I've approached my work as an equal to my colleagues. And for me, this has been important because that helps me to deal with colleagues even when they are much more senior in age or senior in the in judicial experience. Knowing that I'm unequal, justice helps me to leverage on some of those areas where otherwise I would have felt intimidated. Secondly, in approaching my work, and this is a principle I have adopted, I have used even before I joined the bench, but even now, is giving, when I'm doing a task, I give it my best. I give it my best, and I also remain true to myself, so that I'm at peace with my conscience. Of course, in doing that, I've also tried to be as true as I can to the Constitution, to remain grounded in the Constitution and in the law, so that my beliefs, or whatever I believe is the decision, I must find the basis for it in the law. And the law here is widely defined. It can be the Constitution, it can be our national laws, but I've not hesitated to make reference to the international human rights instruments, and also to make comparative examples from other countries where I believed that this helped to make the case that I was making. I've also been mindful of the space that I occupy, that I represent the voiceless. I represent the voiceless, and that it is space that I must very, very carefully use when I'm deciding any matter that is brought before us. And then the other one has also learning to read between the lines, because some of these cases, sometimes the parties, the way they present them, the cases are much more significant than the way the parties present them. So as the court, you need to be able to say, this case is as plainly presented as the parties, but this case is really about this X, Y, Z, so that you are able to, in deciding it, you are able to think about the implication, the wider implications of that case, not only on the parties, but also on the country or the law governing the particular issue. Lastly, very lastly, I wanted to make the point on the issue, is it important to have women on the court? I would say yes. We need to have the women's perspective on the court. We need to, in our case, the Constitution also requires it, so it's also an issue of constitutional, fulfilling the constitutional requirement and the mandate of equality. And women make a difference. There are many times when I've talked to my colleagues, and they have senior colleagues, we would be discussing a case, and they would ask me, Esther, how do you know that? And I say, I was there. Before I joined the bench, I was there, I've lived, I've experienced this, and this is what happens. So sometimes colleagues may make decisions. When you're on the when you're on the bench, you may lose touch. You may not be able to clearly appreciate some of the issues, but having these different perspectives makes a difference, and sometimes that helps to make a decision that meets the ends of justice. I wish you luck in your endeavors as students, and may God bless you all. Thank you.
Okay, kid.
Well, thank you very much, Esther. Thank you. And now it's the turn of Justice Sotomayor.
I think Benedetta is aiming to embarrass me as much as she can. Yesterday, she had all those people speaking about me, and today you have all these wonderful justices speaking before me. I cannot compare with them, but I will share some of my thoughts. Stephen, if I can impose on you, you already know that I can't sit still. So I have to walk around. Could they put up the lights? Ah, much better, isn't it? Hello. They're amazing, aren't they? Yes, they are. I divided my talk a little bit like all of them. I start with the historical setting of the role of my court, the Supreme Court, in gender equality in the United States. And I start by saying to you that the courts in the United States have not been the leaders. For the reasons that Rosalie described historically. Our jurisprudence in America was no different than in Canada. For centuries, the rights of women were defined by their husbands. And that was deeply embedded in American jurisprudence. Justice Bradley in 1925 announced that it was a core principle of American jurisprudence that the rights of women were controlled by her husband. So, if you start from there, you understand the resistance that our court had to recognizing women's rights. We have cases in which the court said women should not be lawyers. They cannot deal, they're too sensitive, too delicate to deal with the harshness of law. Women can't be bakers because it's too hard a job. They don't have the physical strength. Women can't vote because the Constitution doesn't permit them to vote. So what brought the changes? Women did. Women got the American right to vote, the suffrages, by starting a women's movement for a constitutional amendment in 1920 to secure the right to vote. In some states, women had the Equal Rights Amendment passed to get gender equality. As far back as 1875, Montana passed a state constitutional amendment. We still do not have a federal constitutional equal rights amendment. But we passed legislation, Title VII, which requires the equal treatment of women. And women have continued to lobby for rights, including for rights of equal pay and for other benefits in our society. It wasn't like in Canada until the 1970s that the court began to recognize some rights for women under the Equal Rights Amendment. That recognition came as a result of the work of one woman, my colleague, Ruth Bader Ginsburg. She is now on our court, and she continues to influence my court. But she was the lawyer who headed up the Women's Division, Women's Rights Division, of the American Civil Liberties Union. And she had an idea. If men were treated differently than women, if men weren't given benefits that women were given, it would be more likely that the court would say, that's not right. Natural, right? You can't disfavor men, right? So she started to bring cases in which men were denied something women had. The first case was a father whose wife had died or left, I'm not sure, and he was the sole caretaker of his children. And women at the time were given a tax benefit for being the sole caretaker of their children. Ruth went to court and said, violates the Equal Protection Clause of the US Constitution. You cannot treat men differently if they're doing the same thing as women. What do you think the court said? You can't do it. The second case involved military officers who were denied benefits that women got. Second case, the court said, women can't be treated better than men. And finally, Ruth began to bring cases where women were being denied benefits that men got. And the legal principle is now established that you have to have equal treatment of women and men. We have not reached Rosie's ideal of equality yet in America, but we have at least that principle. And so who was it that brought the court a step further in its jurisprudence? Ruth Bader Ginsburg. In 1989, she convinced the court that stereotyping women, that making decisions based on stereotypes alone was non-constitutional because there was no reason for it. And the court, accepting her logic, later in a case when she became a justice, the first case she wrote, the Virginia Military Institute, the court finally announced, we will no longer accept reasonable, rational review of decisions to treat women differently. The government can't say, we have a reason, and that's enough. We have to say more than that. Whatever your reason is, we are going to give it more scrutiny, more review. It has to be fitted to the need that you're addressing. And it's called, in American jurisprudence, heightened scrutiny. And that standard of review was a new one. And it's now a part of our American jurisprudence. And it's all the result of the efforts of my colleague. So if you want proof that a woman can make a difference, she is a living embodiment of it. But then how does that translate to what happens on the court as an institution? We have had 4 women. You heard about the first in 1981, Sandra Day O'Connor. But it took 12 years for Ruth Bader Ginsburg to come to the court in 1993. It took 15 years for me to come to the court. I was appointed to the court in 2009, the same as Esther. So we share the same number of years. But then the 4th woman came to the court a year later, Elena Kagan. So now there are 3 of us because Sandra Day O'Connor retired. Do we make a difference? I have the same answer as Manta. I think so, but I don't know. There are many studies in America on the difference that female judges make. There are many, many studies that show in a lot of different areas, women have had significant impact on jurisprudence. The issue of women's equality, I just showed you one very big impact, but that's been true in state courts throughout the country, on courts generally. As women have come to the court, there has been more equality in the fields that you would think of, family law, but in some that you don't think of. In America, for example, there's a very famous study that reviewed the decisions of bankruptcy courts and showed that judges in bankruptcy court were treating women who were debtors very, very different than male debtors, and showing that the female debtors were not being permitted to reorganize their businesses and start over. That study resulted in some very close review by Congress of the practices of the federal bankruptcy system. And those practices changed to ensure there was equal treatment of men and women. So there are some things that American academics have been able to prove with reliable evidence. But Manta raised the more fundamental question which is, what difference do we make? Well, to each other, there are critical masses. Martha's right. I don't feel the same aloneness that Sandra Day O'Connor and Ruth Bader Ginsburg did for nearly 20 years. They felt like sisters to each other. They were so much sisters that the male lawyers would often confuse one for the other. Now, you do understand that one pretty much has had white hair most of her life, and the other is this tiny, tiny little woman who's very small and exceedingly long face. It's hard to confuse them, but men do it all the time. They had T-shirts, and Sandra's T-shirt said, "That's Ruth." And Ruth's T-shirt said, with an arrow, "That's Sandra." And they would sometimes stand together to remind people of this, okay? When I came to the court, Ruth left on my desk in New York. She sent, I shouldn't say left, the day after my name was nominated, little package with a note. Inside was a white collar to wear under my robe, a jabot, with a note that says, "I hope you have an opportunity to wear this soon." Now, there's a tradition that when a justice is nominated by a president, none of the existing justices talk to them. It's a tradition born of a little bit of a chinks. You can curse them if you talk to them, so they don't call you. But it felt very nice that Ruth reached out to me. To this day, Ruth and I agree, I don't count this, the newspapers do. We agree 96% of the time. Is there coincidence? Perhaps. But I think that probably, more likely, we share some of the same sensibilities about issues involving equality, because we both have experienced it in very personal ways. What defines a woman's view is difficult, if not impossible, to say. No one judge speaks for all women. And there are some men who speak better for women than women do. But we do represent a part and a large part of the society. And so to the extent that we are present, we are a voice in the decision-making that raises the level of discourse in the society. We are a society that is more equal when you can look at a court and see that it represents the entire society, not just a piece of it. And so, for me, it is a strength to have and share my time on the bench with other women. But I learn as much from them as I do from my male colleagues. But I think that in the end, there is more legitimacy to what we say when we are willing to work together and to speak in a voice that recognizes, borrowing Chris's term from yesterday, the dignity of each other. And so that is the history of my court and my time on the bench. A little bit like Martha, women's issues were not the driving center of my private life. The driving center of my private life was civil rights. I was very involved in civil rights for Latinos, for obvious reasons. I am a Latina. And so a lot of my life before the bench involved those kinds of questions. But in reality, you can't separate out civil rights, gender rights, human rights, the respect that one gives or has for people, or even be a woman in this society where at some point you don't recognize that gender plays a role in what you do. There was an article this past month in American newspapers of a study that was done that showed that the 3 women justices were interrupted 33% more time by our male colleagues. So, what accounts for that? There was a lot of speculation, most of it around the fact that it is very, very likely that, as with all human situation, men interrupt women more all the time. So why not justices do it? The one consoling thing about that report is that our Chief Justice went and has changed what he's doing now. Ever since the newspaper report, when one of the male justices interrupts us, he waits for that male justice to finish, and he says, counselor, to the lawyer who was talking, please go back and answer Justice Ginsburg's question. Or please go back and answer Justice Sotomayor's question. Is change possible? Yes. But you have to have the heart, as Suzanne said, and the willingness to be a participant in the change. And so that's why it takes not just the newspaper article and not just women being there, but it takes a Chief Justice, a man, to recognize when injustice is happening. And so that's your challenge. You're the future, right? You're the law students. You have to go out and make a more equal world. And you will have to choose what kind of person, what kind of lawyer you want to be. But more importantly, you have to choose what kind of world you want to live in. Because a more perfect world, borrowing a phrase from the American Constitution, doesn't just happen. We, together, have to make it happen. And you've heard how these women have contributed to that process. In 30 or 40 years, if I come back to this university, I will be asking any of you who are around, what did you do?
She was too far away. Well, thank you very much, all our speakers. And now we are going to have a small break, 10 minutes, and then we'll have the Q&A session opened by the remarks of our 2 distinguished discussants. Thank you.
Se riprendiamo il posto, ci sediamo.
Okay. Thank you very much for being here again. And now we have the second part of our seminar, and I leave the floor to Professor Lee Epstein from the Washington University, and then to Erica Rackley from the University of Birmingham. And then, our thought, Chris's and mine, was to, after their remarks, to give a second round of short remarks to our justices, and then I'll leave the floor to Chris and to Alex Schwartz that joined the minority of this group. Okay? Okay, so Lee, please, the floor is yours. Thank you very much for being here.
Thanks so much to the organizers for inviting me. Though I do want to tell the students I'm a little bit of an odd duck here. I've been teaching constitutional law for many, many years. If you turn, you can see the color of my hair, so you know how many years. But I am actually a data-trained social scientist, and so most of my work entails using statistics to analyze big data sets. As you probably can figure out, I have been accused of being a reductionist in my studies of judging, and I plead guilty as charged, I suppose. With that, though, let me try to pick up on two threads of the conversation this morning. One concerns sort of the female life experience and its effect on judging, and the other are some workplace challenges that were mentioned. And I want to talk a little bit about what the data, how the data speaks to those issues. So let me start with life experiences. I think Justice Sotomayor mentioned that there have been many, many studies of the effect of gender on judging. And I thought I would just tell you what Bertha Wilson said, the first female justice on your court, Justice Sabella, what she said when she started reading some of these data studies. She says, the research overwhelmingly shows that gender difference has been a significant factor in judicial decision-making. Our first female justice, Sandra Day O'Connor, who you heard about earlier, had a very different reaction to the studies. She said, there is simply no empirical evidence that gender difference leads to discernible differences in rendering judgment. Really different reactions to reading the studies. It turns out back then, both justices were correct. It really depended on which study that you read. What was the problem? The studies went out, the researchers went out, and they compared how male and female justices voted in lots of different kinds of cases. If they found a difference, they attributed the difference completely to gender. Right? When we know that men and women differ on many, many other dimensions. Justice Cartabia pointed this out, right? You talked about how you were young, you were an academic, you were from northern Italy, and so you were different than your colleagues. And many, many of the early studies reached mixed conclusions for this reason. So we went out and we tried to fix this. How did we do that? We used a fancy statistical technique, but it's actually quite simple. We took two justices, or judges, who were very, very similar on relevant dimensions, their age, their background experience, where they went to law school, their ideology, their partisanship, except one in the match was a male judge and one in the match was a female judge. And then we compared their voting in 15 areas of the law. The most relevant finding, in 14 of the 15 areas, no difference between the male and the female judges, right? So once we made the apples to apples comparison, very little difference. We did find very substantial differences in one area of the law. Guesses from the judges. What area of the law do you think you differ? Excuse me? Many of you pointed this out in your remarks. In gender-based employment cases, that's where we found the difference, and it was quite substantial. So these are cases in which somebody, usually a female, not always, is alleging discrimination in the workplace based on their gender. That's where the male and the female judges differed the most. Also, as part of the study, we looked at the effect of having a female judge sit with male judges. Again, we looked at 15 areas of the law. We found that a man sitting with other men versus a man sitting with a woman, no difference in 14 of the 15 areas of the law. But again, in gender-based employment discrimination cases, we found a very big difference. When men sit with women, they are more likely to rule for the plaintiff, the person alleging workplace discrimination, than when they sit with two men. And it's a quite substantial and significant difference. I've reported this finding to many judges in the United States, and the women in the room always go, yes, yes, because in those cases, those were the cases I was pounding my fist and trying to get the men to understand the degree of workplace discrimination. Okay. So those are our results. I'll be interested in some of your reactions later. I very briefly wanted to touch on workplace challenges. And again, Justice Sotomayor, in the last part of your remarks, you commented on the interruption studies that have been done in the United States. The results of these studies that the female justices are interrupted much more than the male justices are not surprising. There have been many, many studies of how men and women interact in the workplace when they are deliberating in small groups, and the results of those studies are quite consistent. Women are talked over. And that's what we saw in the US Supreme Court with the interruptions. And I'm very glad to learn that our Chief Justice has tried to remedy that. There are other interruption effects that may be more difficult to remedy. For example, I'll just give you one. After a female judge has talked and a male judge comes in to question, they tend to raise their vocal pitch. Now that's kind of an odd thing, right? And if you listen to the oral arguments, you can actually hear the vocal pitch increasing. And we know from linguistic studies that that's sort of a power play, right? That's seizing the field, right? So that's one thing. But there's a downstream consequence of vocal pitch raising on the part of the male judges, which is the female judges then disengage from the argument and become much quieter as the argument progresses. So I'll be interested to hear, that's just one of the little findings from some of the interruption and workplace studies. I'd be interested in your reactions and whether you sense that, and if so, how it affects the deliberative process on your courts. So I'll end there. Turn it over to the second discussant.
Thank you very much, Lee. And now the floor is for Erica Rackley.
Thank you.
Thank you.
one of the things about speaking last on a panel is you find yourself in the position where everything has been said, and so your job is simply to say it again so that you remember that it's been said, to prompt questions. And I was thinking about, a few years ago, I wrote a paper where I likened the experience of being a woman judge to that of Hans Christian Andersen's Little Mermaid. And for those of you who don't remember your fairy tales, Hans Christian Andersen's Little Mermaid was a mermaid who sold her voice to walk on land next to her prince. And it has a terrible ending. Disney doesn't have the right ending, of course. And I suggested that to be a woman judge was to be a bit like Hans Andersen's Little Mermaid. And the woman judge faces a stark and brutal choice, her voice or walking alongside her prince, being a judge. And at the time, this worked pretty well. And of course, the analogy only works if the Little Mermaid has a voice to sell in the first place. And if there is something specific about being a woman judge. And I think that what is clear today is that there is. That women judges are different, they are making a difference, they are transforming not just the outputs of judiciaries, but transforming the way in which our judiciaries work in many and varied ways. And it's clear that they are doing so in terms of how the public responds to judges. If we only ever see men as judges, and we only ever see women judges in fiction, then the default image of a judge will always be male. I sometimes worry that we talk about women judges and how this reinforces the word judges as male. We often talk about women judges and how that can be problematic. But more importantly, the visibility of women judges, and particularly in my own jurisdiction. I come from the UK, where we have one woman on our Supreme Court. We have had one woman, Lady Hale, on our Supreme Court for 13 years now, and there's still no sign of another woman appearing. We have some appointments coming up, and all fingers are crossed. However, I say that with some caution, because there have been 16 appointments since Lady Hale's appointment, and they have not yet found a woman, let alone anyone from any BME background to put on our court. So the woman judge is very visible. This can be chosen and unchosen. And I was struck by the comments, particularly of Susan Baer, but I think a number of the justices were saying this about being a justice in the world, having to go out and to speak and to use that visibility in a way to challenge perceptions both of being a judge, but also about people in positions of authority, public figures, and so on. I think another theme that came out of what the justices were saying today is about the culture and ethos of the judiciary, changing practices within how the judiciary works, so the sort of internal practices, how they are running, the roles within the courtroom. I think it's interesting that we often, there's a sort of the hidden, the behind the scenes of what happens during judicial discussions that as academics we're always incredibly interested in and wish to be flies on the wall. And we've started to have conversations about how those discussions happen, obviously within correct boundaries. But we know that the women have spoken about challenging their colleagues' points of views on particular views. We also know that women judges are acting as role models and raising expectations. And I think one thing I hope is different today for law students today is I hope that you are thinking about being judges, you are thinking about being on the Supreme Courts, and you are thinking about going out there. I think that my personal view is that I want women to be that it's not simply a matter of luck and it happening, that we are ambitious and challenging and want to get out there. And I think that having such strong role models in our judiciary now, that we shouldn't be still thinking about single figures, and we shouldn't be embarrassed about saying, you know what, I've come to law school because I want to be on the Supreme Court. Why shouldn't that be something that women can say? And of course, as Professor Eckstein just acknowledged, women judges are making a difference to the substantive jurisprudence. We don't know how this is. And I think it's okay for us to say that this is happening in many different ways and that we might not be able to point to it. I liked the idea, the cross-pollination that just Bella talked about, I think is absolutely right. My own view is that hopefully one day I'll have to find a whole new area of research because you won't be able to tell the difference between men and women judges because there's been those interactions between them. So I think it's okay to sometimes to not find difference. And I think that that can be a result of difference if that's not too contradictory. And I recognize that that can be controversial. I think that there are people who still find it challenging, and we are moving on, the idea that judges do bring something of themselves to their decision making. I think that that is something that it can be hard to think about. I think if we think that, follow that through, if you said to people, you know, it really does make a difference that you had this judge rather than that judge, for the parties before judge, they may well think, well, I'm not too sure about that. You know, I'd like to know that I'm going to get the same decision on the day from Mr. Justice A and Mrs. Justice B. And so, whilst my own view is that judges do and ought to bring their views, I can see that that can be controversial and problematic. And I think that one of the things that struck me most about, and the other theme I'd like us to perhaps talk about in discussion, is, as I say, I come from a jurisdiction where we've had one woman in our Supreme Court. 1 in 5 of our senior judges are women. And we've had women entering our legal profession since the 70s. You know, we have women in our legal professions, and it's not making a huge difference to our judiciary. And so that is why, and I think why it's so important to keep making the case for why there should be more women judges, and also why there should be more diversity. In the judiciary more generally, I think it should become a broader conversation. I agree. We reduce people down to talking about women, and of course we're all many things other than simply women. But we do still need to make the case. In my own view, is that the battle has not been won for why there should be diverse judiciary and why that is important. And I think that the strongest argument for that is the substantive contribution that women judges make to the courts. And it's only by recognizing that the difference that different judges bring, women and other non-traditional judges, and it's only by treating those differences as something to be celebrated and not something to be mistrusted, that we will have judiciaries that as a whole are best positioned to do their job, and that's to deliver justice. So I would like, perhaps in conversation, for us to think more about how, I would like to hear more about how the justices feel that they are doing this, not necessarily in outcomes, but how it's working in everyday life, both on the court and outside the court, and how that we can go out and continue to make these arguments for jurisdictions where I think the arguments still need to be made. So that would be where I'd like to go.
Very much. One second. Would you first? Now? Yeah. Okay. So, and now I leave the floor for further remarks to Chris McCradden and then to Alex Schwartz, always from Queen's University, Belfast. Thank you, Chris.
Thank you, Benedetta. The reason I wanted to intervene now is because there seemed to me to be, from the last comments, really very interesting questions that we're now beginning to explore that are more controversial. So I just wanted to highlight some of the controversial issues, because there's a remarkable degree of consensus in terms of the panel before the break. And I think that's in itself a very interesting development, that there is such a degree of commonality. But I wanted to see if there are differences that maybe we could open up. That's not simply for the sake of being provocative. I'm not intending to be that, but to try to continue the conversation that Erica mentioned that we should be having. So there seem to me to be maybe 4 different arguments on the table as to why there should be women judges. Or as someone put it, why it's the starting point should be why there should be women judges rather than why there shouldn't be women judges. But these are 4 different arguments. And one argument seems to be an equality argument of a traditional kind. A woman who is an appropriate member of the court, why on earth shouldn't she be on the court? From the point of view of the fairness to the individual. So there's no reason to exclude a woman because she's a woman. So that's a simple fairness argument. And it applies in the context of other kinds of employment as well. There's a second kind of argument that seems to be going on, and it's more specifically to do with judging and courts, and it's to do with the legitimacy of the court. And a court that is seen to be more representative of the population is seen to be a more legitimate court. So from the point of view of convincing the population that the judgments are right, that they should be obeyed, we have, in many situations, more likelihood of it being legitimate if it is a more diverse court, particularly in a diverse society. That, I think, is easy. The third argument is different, I think. And the third argument is we want the judgments to be more influenced by feminism. And women are more likely to be feminists. And so there's a very interesting project that Eric has been involved in, and others as well, where some judgments are being rewritten in terms of the feminist judgment project. So there have been Canadian, there have been recently in Ireland, there's been a feminist judgment book published where you re-examine what a judgment would look like if it was written by a feminist. But of course, as many of you have pointed out, men can be feminists as well. So that isn't a specific argument as to why women should be on the court, except that they're more likely to be feminists. The fourth argument's different again, and it's the fourth argument that intrigues me most, which is what our other panelists have been mentioning, this question about whether there is something specific about being a woman that brings the life experiences of women onto the court. So that is more intriguing because it raises the question about whether other kinds of identities also play that function. And so the question of whether you're gay or whether you are disabled or whether you are Catholic or whatever. So it's a question that is broader than the issue of women. It's about identity. And it's that fourth argument that is intriguing because I think it's the most controversial. Because there's a danger of essentializing the individual. Because there's a question about neutrality that Susanna Baer mentioned. And it's in that context that I think I want to open up the debate a bit more, because we are then getting into an area about whether there's a potential problem. And the problem seems to be around the notion of, if you like, of the rule of law. Because the rule of law seems to be about justice as a government, as it were, of laws rather than of men. It's about, to a degree, predictability, certainty, and Erica mentioned that as well. And in that context, if I could bring a slightly different perspective, and it's this perspective of the litigator. Right? And some of you have been litigators, but now you're not. So I wanted to re-engage the perspective of the litigator. And from the perspective of a litigator, I think there may be interesting differences between the courts here that are represented today. And In the common law context, so, you know, the context of common law judges, and I'm including the Canadian context and the Ugandan context and the United States context. To a degree, the Israeli context influenced by the common law. The perspective is, it's the representative of the party who controls what the party is said to be saying. Right? So when I go to court and I'm representing a party, I want to know what the party is saying because I'm representing the party. So when a judge, as it were, takes over that function from me, I get very uneasy. And I particularly get uneasy if some of that perspective that's being brought to bear is a perspective that is behind closed doors, where aspects of the individual are being drawn out in private conversations that I, as the representative of the party, don't know about. And that applies, you know, it's the notion of judges acting sua sponte, on their own initiative. And in the common law, that is a very controversial area. Now, in the civil law, I think it's less controversial because the judge, in some respects, and I'm open to contradiction on this, is supposed to act sua sponte to a degree. But it makes me, as a common lawyer, uneasy. Simply because I don't know, therefore, what kinds of arguments I can make that are going to be the key arguments that will influence the judgment. So that degree of a hidden conversation makes me uneasy. Should I be, or should I not? Should I not be worried about degrees of sua sponte judging? Because I am. Thank you.
Alex? Yeah. Alex, please.
Conscious of the volume of my voice, actually, following the rest of our discussants today, so I'll try not to be guilty of what I think lots of men, I think, definitely do, intentionally or unintentionally. I had one question, which is the normative question, following on from what Professor McCrudden said for the justices, and another question, which is, I suppose, an empirical or methodological question for Professor Epstein. So I'll start with the normative one, and it's actually comes to me inspired by my teaching experience. So for the last few years, I've been teaching a course on comparative judicial politics, which looks at research, including a lot of empirical research from a number of jurisdictions, including the jurisdictions represented here today. When the students that I teach begin that class, they come to me as third-year law students, and they still have, I think, a fairly black letter understanding about how judicial decision-making ought to work, at least. They think, you know, judges ought to apply the law as best they understand it. And over the course of that class, we cover a lot of other extra-legal factors that might influence the way judges understand and interpret and apply the law. And by the end of the class, they've kind of come along with me and see that, okay, well, you know, judges disagree, and when they disagree, why do they disagree? And when they disagree, perhaps there are extra legal reasons behind that, strategic motivations that they have in mind about the authority of their court, ideational or ideological influences that might influence their decision making, attributes that they bring to the court in terms of their personal background, so gender, ethnicity, religion, and so on. So they've come along with me on this journey, and they've come to accept that there are these extra legal factors, but they don't like that there are these extra legal factors, with the exception of gender. So the students seem to think gender, it's okay that women judges might be influenced by their experiences as women when they come to the court. But we don't want judges to be influenced by their religious convictions in how they decide cases. And we don't want judges to be influenced by their sort of naked partisan political preferences. And I'm interested in why, and I sort of share that intuition with my students that maybe there's something different about gender or the life experiences that women judges bring to the court. But why? I want to sort of pose that question. Is there something more desirable about a gendered perspective than there is about a religiously informed perspective on the court, or just a straight up political partisan perspective on the court? I mean, it's interesting that the US Supreme Court, for example, isn't terribly representative of religious diversity within the United States. Right, yeah, or, yeah. So, so you know, maybe that's fine, or maybe that's something to worry about. So that was my normative question for the justices. And then empirically, or methodologically, the lack of, let's say the disparity in terms of the research between in the United States and in other jurisdictions, I wonder if that could be just down to its inconsistency of methods. So the other studies that have been done, for example, in Canada, which have found much broader, more widespread influence of gender on judicial decision-making, including in the criminal law context and so on. That might just be because they're not using as careful methods as the matching methods that Professor Epstein was describing. But I wonder also if it might be actually, there might be a reason for that, in the sense that in the United States, other factors are drowning out the influence of gender in these other issue areas. So political ideology, for example, as the attitudinal literature in the United States would find, is such a powerful influence in the US. Maybe that's drowning out the influence of a gendered perspective in ways that aren't happening, say, for example, in Canada. So I wondered if you might comment on that, Professor Epstein. Thanks.
Thank you very much. Thank you, Alex. Thank you very much. So I'd say now to start our second round among justices, again in alphabetical order. So Rosie, it's, I think, 5 minutes each. Let's say, I mean, roughly, okay, but roughly 5 minutes each. Roughly.
Okay,
So, I mean,
then I'm going to talk really quickly, because I think these commentaries, the four of them, have raised some very interesting questions. And one of the great advantages of being several hundred years old and having lived to see the trends is to find myself on a panel of women judges where somebody says and actually believes, how come gender isn't a problem, but other aspects would be? And here's why. When Bertha Wilson made her speech, and then Claire Leroux-Debay, two of the great judges on the Canadian Supreme Court, both feminist, both human rights oriented, Bertha made her speech in 1980-something, and then Claire made one later saying, women judges do not make a difference. That was the debate. But I can tell you that the articulation of the problem was, do we want women judges because they will bring a bias with them? And that is the women's bias, which always struck the women as odd, because representing the status quo was not considered a bias, but representing a wider perspective is a bias, which brings me to your point about do we want feminism and why do we want women? I think I give you the answer my parents gave me when I asked them why I can't have a dog. And they said, because. And so the answer, women are 50-something% of the population. They should be occupying every single profession, working environment to the extent of their numbers. Why not? Why is the legal profession having this conversation about how many should come in? Is it okay? Should we have other identities? Of course, we should have everything. Because we are there making decisions and judging a population which consists of everybody. So it's not a conversation we even need to think about. We should just be doing it. Here's what happened in Canada, and it's interesting. The UK makes no sense to me at all. It is so bizarre, because what's happened in Canada is we graduated from those early discussions about should we have more women to let's get more women. The women turned out to be great, 99% of them, some of them less great, but same was true of some of the male judges. And so it normalized eventually women being judges. So we don't ask that question anymore. And we don't even ask whether the men should be feminists. You can find a complete symmetry of views among men and women judges in Canada now, because at the beginning of our charter, we got the supply side rhetoric from the Supreme Court of Canada, which the next generation of lawyers and judges bought into, namely inclusion, expansive, not feminist, not just feminist, all inclusion. So that's the window in which judges in Canada behave as judges. So I think what's happened is the conversation hasn't changed in Canada, but the perception of the conversation has changed. So I'll give you one story. When I became a judge 100 years ago, my older son was 3, and I read him a book called If I Were a Bus Driver. He was in the courtroom when I was sworn in. There were no other women judges, just me and 8 black-robed male judges. So I'm reading him this book called If I Were a Bus Driver. He loves it. He says, when I grow up, I want to be a bus driver. I look at him because I'm a Jewish mother and say, don't you want to be a judge? And he looked at me and said, curiously, only girls are judges. Because the only judge he knew was a woman. So that was the stereotype. The stereotype has completely changed. And what are we in now? I think the territory we're in now, and perhaps the United States and Canada are unique in this. We went from worrying about gender to worrying about ideology. And the conversation today is pushing back. Those who didn't want women are now saying they don't want judicial activists. They don't want judicial politicization. They want people who are neutral. And what they mean by that, again, is they want people who defend the status quo. Because they never call judges activists when they shrink rights. They only call them activists when they expand rights. And so you have the rhetoric of partisanship, of ideology, and legitimacy tied in together, sometimes with gender, sometimes with religion, but it's all about delegitimizing those who come to the law with an expansive view about what justice is, what law is for, and who it's for. And that's what we have to push back against. So I think we've largely graduated from, do women judges make a difference, to, duh, yes, they do, and they can. Do men make a difference? Yes. Judges make a difference. And let me end with this. Your fear of, should I be afraid? And the rule of law question. As a representative. I think once you have a system of appointment that produces judges in whom you have confidence, you have to assume that what will happen when we retire and kick ideas around with each other, because we always do, it will be done with integrity. You have to leave that possibility to us, because you will never have transparency except through our decisions. We're not going to speak about them afterwards. So you shouldn't be afraid if you're content with the way we're picked, because we're going to do a job that we think protects the public interest, in our view. But I do worry about rule of law concerns, because I'm a nervous person about the concept of rule of law anyway, because rule of law brought us apartheid, segregation, Nazi Germany. I'm much more comfortable with a rule of justice, and I think rule of law is a term most people don't understand. I think it has a positivist connotation, which is Diceian, treating everybody the same, and I think that's not the world we're in. I think we've graduated into a world that understands a broader framework for how we see law and justice, and that is democracy. Not just elections, free press, the right to dissent, all of those instruments of democracy that keep society healthy, not just the law. It's the quality of the law that counts as well as just the law. Otherwise, I have nothing to say about any of your comments. Oh, let me end with this. I'm interrupting myself. Canada, you would never, ever have criticism of the Canadian Supreme Court for interrupting. When we have 2 or 3 people pushing the button at the same time, 2 people will always say, oh, sorry, do you want to go ahead? I'm awfully sorry. We are so Canadian. So when we read about the United States going like aggressively, it just makes us smile because it would never occur to us to interrupt a colleague. Just never. Which doesn't mean we don't violently disagree with one another from time to time. It's just every culture, every judicial culture, every national culture is different. And I must say, I'm really surprised because at the beginning there were no women lawyers, no women judges, at how absolutely normal it's become in Canada. Not just to have judges who are different genders, but to have a culture of progressive, open-minded judges from all walks of life, all economic levels. It's not just the usual candidate pool we used to see, and it's made a difference. I think our judgments are better because we have the benefit of each other and each other's experiences.
Susanne, your turn.
So on the women on the bench, Rosie said it all. I suggest, also for research reasons, at least an addition, if not a modification, if not a full change of perspective and questions. Because I think what we agree on here is the question of how can diversity in life be adequately taken into account by courts. That's a different question, though, from some of the questions which have been focused on right now. And that's why I'm a little worried and would like to move our conversation to a very important change, which is not essentialist, which has to do with the heuristics of judging and not as much with the being present. However, it is, and that's where we also agree on, I think, closely related and should never be forgotten that it is closely related to the mere existence of judging. So there is no either essentialist or open-mindedness discussion, but what I think we're trying to say is that the addition of diverse life experience, background, etc., to a collegiate finding of a judgment, to collegiate decision-making, is a procedural device to ensure that diversity is taken adequately into account. So the presence matters, and there's nothing without the presence of diverse people, including men and women, etc., on a bench. But it's not, we shall never stop there. So if you're looking in sociological studies to what bioessential men and women, so-called, do on the bench, that's a very interesting starting point. I'm personally grateful for the studies. They cannot be done in most continental systems because you will never know how we voted. And part of them, however, would be even more interesting when we would look at what kind of experience exactly shapes what kind of take on what kind of legal field, and how diverse are the perceptions of the facts as different from the perceptions of doctrine and legal points, etc., etc. So the consensus we have, if I may assume that, is that these justices here do not pretend that the rule of law just so happens. But we all are courageous enough to admit that we as persons and our colleagues as the persons they are bring something to judging which we cannot forget, we should not pretend to forget. And the minute we face this, and I think Rosie said that in the beginning, the minute we face this, we enable ourselves and our colleagues to face our bias, to face our presuppositions, to face how limited we are in understanding the world, but also allow for others to add to our understanding. And that's my response to the rule of law danger. I think you should be excited, happy to see one of these, or somebody who thinks like that, on the bench. Because they are the only ones who will guarantee for you, and every other person who seeks justice in front of a court, that you will be adequately listened to, taken into account, even if you tell a story which sounds weird to me. Even if you have a life which I have no clue what it looks like. Even if you make an argument which has never been heard before. We are so super committed to rule of law, doctrine, the Constitution, radical people, critical people, are more committed to that than those who take their being there for granted, usually, interestingly. We are more formal, we are more rule of law bound, we are more into, that's the law, by the way, and not ideology, that everybody should be totally excited. But in addition to that, we are also honest to admit and to say, because we saw it in the history of the exclusion of people from justice, that we are people. So Albie Sachs, from the South African Constitutional Court, in his book, in his wonderful book on judging, says, you know, the beauty of it is to bring legal rationality and compassion to the attempt to deliver what we were meant to do on those benches, meaning justice for as many as possible, in recognizing their difference and recognizing their diversity. So I don't see, and that's the rare moment of a tiny bit of a disagreement with Rosie Abella, I don't see a contradiction between rule of law, democracy, and fundamental rights protection, because in my post-1945, to be emphasized, version of it, these go hand in hand and shall never be separated. Rule of law, as lived in democratic constitutionalism, meaning a commitment to fundamental rights for all, is a commitment to be honest about the diversity out there, the limits of our knowing it, and the attempt to bring it into a courtroom to adequately take account of what things mean to people in their lives. So I think the point we're making is, yes, we're women and many other things. We are honest about it. We admit that it matters. Everybody should admit that it matters. So the next study should be on masculinity in courts, ways of refusing to accept an argument, ignorance and blind spots in judging. Which areas are heavily infiltrated, infected by bias which has been around for 1,000 years and never has been challenged? So why should, to be a little bit provocative, only a little bit, why should men be on courts? They didn't deliver on many counts. Racist judging, sexist judging, homophobic judging, that all happened, right? In the name of law. There was a problem. Who did it? I will not engage in an argument. We'll never do and say, you know, it's been men. I'm not into those kind of theories. But what I would engage in is saying, it's been people who pretended that there's something neutral just happening, falling down from those books, bloop, into judging. That's not the truth. What we're into is critical reflection, and diversity on the bench is a method, is a procedural promise to try to do that. There's never more, but that's a little bit already. Thank you.
Daphne, yeah.
Okay, so I would like to offer a concurring judgment to the things that were said so far. And I'll start by, you know, following up on Susanna and making a similar point, that I think that the issue of gender is not a matter of representation, but rather of reflection. Reflecting one's life experience, which is very different from a very essentialist and shallower view of representation. I claim to represent the women's group. I don't claim to represent anyone. I hardly represent myself. Yes, so I mean, but reflection is very important, and reflection can also be flexible enough and complex enough to also include in it also the other aspects of our identity and life experience, because we are not only women, as we know. And I think this is also very much connected to the distinction that you tried to offer between the various rationales for including women. And you made a distinction between the aspect of legitimizing the court, which was the second category, and the issue of life experience, which was the fourth category. And you were not concerned at all about the issue of legitimacy, only concerned about the fourth argument. But I think that, in fact, these two cannot be separated, because the legitimizing effect will be effective only if the assumption of the public is that diversity matters, that people actually bring with diversity not only the tag of being a woman or a minority or something like this, but they assume that probably this identity is relevant to what people are doing. So I don't think that we can really separate between the legitimizing effect and our assumptions about the importance of a life experience, not in any, I would say, representative manner, but only as a matter of reflection. Now, if I want to move on from here to maybe a research agenda, so again, with all the humility of now being a judge and not a law professor anymore, I want to just to point to a few issues that I think came from our conversation, but maybe to put a word of emphasis in that respect. I think that although there was a relatively broad agreement in some of the main themes, it's very important to go back and study also the differences between the systems that we come from. Because, for example, methods of appointing judges. Do we come from a tradition of so-called, at least, professional appointments where the assumption is that judges represent only their neutral professionalism, or do we come from systems that acknowledge political appointments not in any bad manner, appointments that are that should represent? So maybe Chris, your difficulties also reflected the legal tradition that you come from, that, and I, to a large degree, also come from, that of only professional judging. But maybe we should free ourselves from this assumption, because it also reflects only one aspect, one perspective, one approach to these issues. To the same degree, and I think Susanna mentioned that, the question is, do we have a chance to offer a separate reasoning, either in the form of minority views or concurring views? So in this respect, maybe we can follow certain kind of research in the Anglo-American legal tradition, and maybe it's easier for judges who function within this tradition to establish themselves as doing feminism in court. And by the way, I totally agree, and I think this is something that Sonia mentioned yesterday, that the concurring opinions are no less important than the dissenting ones, because sometimes even the possibility to offer an alternative reasoning is no less important. And here I go back to Lee's comments, because I think that only counting the votes would not reflect the sophistication of the judging process, because again, I'm sure you agree, but still I think it's worthwhile mentioning, because of the methods of research that you focused on. Sometimes we agree for totally different reasons. And what happens with, again, and there are differences between courts, what happens with compromises that we get to as judges, and sometimes they reflect other things, and these things are not completely reflected in the formal results of the legal process. Maybe one last comment in terms of research methods. How do we choose the areas of law in which on which we concentrate when we try to observe differences? Also here, there may be some issues that reflect one's own specific legal tradition. For example, is there a difference between systems that accept separation between state and religion, and other systems that don't accept complete separation between the law and religion? Maybe this very basic constitutional difference will be reflected also in how gender influences votes on issues of law and religion. So sometimes there are hidden assumptions in various systems, and to make this comparative comparison is even more difficult than we even realize at first sight. To go back to where I started, once again, I believe in reflection and not in representation. Thank you.
Thank you very much. Professor Cartabia. Yeah, your turn.
Thank you. So no representation, but reflection. I agree completely. I took a note saying a court is not a parliament. I completely agree with you in the sense that the question that you ask is one of the most important indeed, how to cope with this fact of being impartial, neutral, taking care of the general interests of the Constitution, and having a personal identities, probably, not a personal identity, but many of them. A court is not a parliament. We are not expected to represent the interest, the ideology, the bias, or whatever you want, the values of the group to which you belong to. But at the same time, your personality is there. How can it be this paradox? I'm here, I'm not making a theory, I'm reflecting of what happened in these 6 years of being at the Constitutional Court. My feeling is that being ideological or partisan in a decision-making process simply doesn't work, especially if you are part of a cultural minority. Because in a court, you do not simply vote. At least in our court, we have first long hours of deliberation, discussion, listening to arguments and to the point of view of others. Then, at the end, if necessary, we vote. Sometimes it's not even necessary because the consensus is clear. This way of proceeding makes a huge difference because your argument taken maybe from your identity, your particular point of view, is effective only if it gives an appropriate contribution to the deliberation, a reasonable enrichment of the discussion. And I happen to change many times my point of view. I go into the court with a certain idea of the solution of a case, and over time, listening to the others, I change my idea, and sometimes I even openly say, okay, I agree with you, I retire my first statement because what you said is more reasonable. And what makes the difference? I think that our specific point of view is very helpful when it helps shedding light on problems rather than trying to impose solutions. It's a matter of an enlarged understanding, a broader understanding of deeper understanding of the questions, rather than to say, I have the right solution. This is something that is not acceptable. Because sometimes I don't feel on the side of my colleagues that there is a bias against different solutions, but they simply don't see the reason why to go a different way. For me, an interesting example was the change that I saw in my court about the relationship of my country, my court, in the European context. The Constitutional Court used to be one of the sovereignist court. We don't have to relate it with the preliminary rulings to the European Court of Justice because, you know, we are the final word, we are have the final say on the Constitution. We don't want to engage in this direct dialogue. In the last few years, little by little, we had some experiments on small cases where it was necessary to engage this conversation. And over time, I saw some of my colleagues, the most close to the European environment, changing their view because they experienced the usefulness of having this kind of exchange of the court. So I think that this is important, the way we try to convey our identities, our conviction, our principles, our values, is more to open more questions than to impose a solution. This is very, very important as a methodological point of view. My final point concerning appointments in the court, indeed, in general, appointments in the workplace, indeed there are, in Italy, many barriers to the top level position in many different places. I've already said something about the top position in the institutional, public institution, political, judiciary, and so on and so forth. But even when you are in power, I am in power, I am in a position of a lot of power in my country, the issue is not over. Then it starts a new adventure, which is to build up your authority in the institution. Power and authority are different questions. And this is a work that is to be done, as Justice Sotomayor said yesterday, slowly but steadily. Is something that we have to learn. And being ideological, partisan, and so on and so forth does not help authority. What helps authority is really to be open to a broader understanding of the problems, because even if we have some ideas about the solution, reality is always more challenging, and there is always something to learn that can be got from other parties, other point of view. And I think that this is one point, that being open builds up an authoritative, more, let's say, yes, more authority in your presence in the court, and gives more fruits to even to the contribution that women or whatever you are can give to the public life of your country. Stop here.
Thank you very much. Esther, your turn.
Thank you. First of all, I would like to associate myself with the views that have been expressed by my sisters here. And just wish to add some few points. There's this issue, I think, which was raised that by, I mean, are we likely to be, bringing bias? Women, is there a bias judging by women? The same argument is never raised for men. And I think that's, an issue. So if we are going to say women are biased, why aren't men biased? I think the difference between us and men is that we are more outspoken about some of these issues, and being quiet. For our male counterparts, they may not necessarily talk about some of these issues that may, influence their outlook to issues that have been brought before the court. Personally, I remember an incident when I was hearing, sometimes we hear applications as single justices, and in the middle of hearing this application, even before I rendered and I was trying to really be very fair to both parties, one of the senior counsels said, oh, wait a minute, it involved a family matter, before the court. So the senior counsel for the husband says, we know your background, you're going to be biased against my client. And I said, well, if women can't hear cases involving families or disputes between men and women, where are you going to get the men to hear these cases? You see. So I think the bias argument has its own limitations, because at the end of the day, we should be looking at how women and men are judging, but to presuppose that women are going to be biased and men are not going to be biased, I think there's a problem there. Secondly, I wanted to make the point that again, related to that is this, apart from the individual, a point that I think Suzanne made, some of the discrimination that we're talking about has been carried on, like the courts endorsed this discrimination against different groups at different times. And who was in charge, So in our presence, I would like to believe that the presence of people like the team around the table is to question some of the rules that have been accepted, over the course of the time, as especially in the common law system, where we have the rules of precedent. Like you say, oh, this matter, it was decided 50 years ago, and therefore, in our own system, particularly in where we were colonized, I've argued before my colleagues, it's very usual for somebody to say, as Lord Atkins said, and I'm like, Lord Atkins lived in his time, 50 years ago, whatever, Lord Denning. But what about the people of Uganda? Is this the same setting? I mean, there are those who are happy to just, continue articulating the principles set by this great judge so many years ago. I mean, I'm not saying everything should be thrown out of the window, but the fact that you have justices on the court who are ready to re-examine, were these principles right? If they were right at the time, are they still right today? And therefore, are they applicable in the context that, particular context, in this case, a developing country or whatever, different system? These are the things that I think we bring to the table. And I would like to share another example where our former Chief Justice was asked to come to me and said, he was trying to, he was very friendly, and he came to me to talk about, how I need to follow the line. And he said, when we have decided these issues, I think, there are issues which are settled. And I'm like, settled? Probably settled by our court. And sometimes there may be 2 or 3 issues. And I remember telling him that, you see, if we are a young democracy, we are less than about 50 years old. Now, if a 50-year-old democracy, nation, is going to say these issues are settled, then the courts in older democracies like the US and Canada, the UK should have closed shop a long time ago, Yes, and I remember him sort of being taken back. But I think so the importance of continuing to question the legal principles, the construction and the interpretation that has been given to, to different situations. I think it's important, and I think when you appoint a court and women with that diversity, they were not there. They were not on the court, so they were not part of that discourse. I think it's very, very important. For me, I think that's a contribution that we need to note for why we need to have, apart from the equality argument, why we need to have women on the court. The other point I wanted to also raise in terms of, because much as I come from Uganda, but of course you realize I represent a bigger constituency, Africa. In our context, it's even more, these issues of bias and precedent and whatever are more complex because we have plural legal systems. You have the written law, and then you have sometimes the religion, which we inherited, and in most cases, it has been abandoned in the countries where we inherited them from. Like some of the laws we apply were abandoned in the UK and in India, and yet they are still on our statute books. You have, then you have another layer of religious law, and then you have the unwritten customary law. And all that is going into, and practices which are not even documented. So when we talk about studies, it was very interesting. I know you've focused on the US system of judging, but it would be interesting for us to conduct empirical studies in countries where you have this kind of diversity and layers of legal systems, interplaying and influencing the judging. So it's important, and it would be, I think, an important initiative of this forum if we could develop this further, because we need, the studies that our colleagues shared with us may not tell the full story of countries like the one I represent. I guess I would wish to stop here. Thank you.
Thank you very much, Hester. Thank you. Sonia, apparently it's your turn.
We have a unanimous court. I join in the opinions of my colleagues. I have a lot of thoughts swirling, and I'm trying to organize them. Lee, just one aside. Yesterday, and I don't remember if you were here or not, when I mentioned my colleague, Ruth Bader Ginsburg, at one point, when she was asked about the treatment of women on the court, said, it is very common for her to say something during our conferences, and that it's not reacted to until a male says it as if it's his idea. And I explained that one of the things I have started to do is that when I notice that happening, I will say, that's what Ruth said. As a small contribution to attempting to point out that there are endemic differences in the treatment of people, whether it's women, minorities, groups that we will never identify fully or can't control for fully. But they exist because not only do people experience them, but they see them, and in some instances they can count them. The voice decibel, the interruptions, that sort of thing. With respect to Alex and Chris's global point, I've taught myself as I examine legal issues to try to break down questions to their essence. And so I started, and I've been struggling as I've sat here listening, with what does rule of law mean? Because until you define that, you can't answer either of your two positions. So, and for the following reason, the definition controls, in part, what you think the outcome should or should not be. And so if you think of, as I think the common law does, both systems do, civil or common law, that the rule of law is a statement by some law-giving body, whether it's Parliament, the Congress, whomever it is in our individual countries, about what the rights, obligations, and responsibilities are of people among each other. Then, if that's how you define law, the rule of law, that sort of objective statement that people can look at and discern how to comport their behavior, then you think, okay, now we're going to have judges who are going to interpret those commands, whatever they might be, in a way that people can expect. So who are the people who are expecting? And that's the point that we're all making, which is it a reasonable man? Is it a reasonable woman? Is it a reasonable person? We have moved society, I think, far enough along that there seems to be a more common place of discussion where we think of it as a reasonable person. But that continues to beg the question. Because if it's a reasonable person, it has to be a reasonable woman. We're 51% of the population. But we don't think of it that way. And we don't have that expectation. Because the expectation is always cultural. We are defined by the culture we live in. And that's why, Lee, I think you're not going to find disagreement between men and women, minorities, or people of differences of any kind. When you do the empirical studies, you're going to get that wide swath of agreement because our cultural expectations, Rose, you said it before, in Canada there wouldn't be interruption because that's a cultural expectation. In aggressive America, it's to be expected. What we have to study is what's the consequence? And when is that consequence legally improper? And no one would say that interruption in America will find a legal solution, including myself, and I'm a woman. Because I look at that problem culturally, and I recognize that it's not susceptible to legal control. But there are many problems like gender inequality, where having that different experience, that different view, leads to cultural corrections that are necessary. It's why we had the correction of legal equality in the United States based on the Equal Protection Clause of the Constitution. It only took 150 years, but we finally got there. If you were a gentleman of the 1900s who had married a wife and gotten all her chattel, have expected that the courts would one day say, oh, no. That expectation is not reasonable. A reasonable person would not accept the treatment of another human being, a woman, in this way. Perhaps that wasn't his expectation, but it is the expectation of the reasonable person. And to the extent that a litigant is arguing that judicially created creature, you as a litigant better be prepared to know how the law is affecting people, because every law affects people. And if you can't anticipate that as a lawyer, you're not doing your job. And so that's why I don't think that different perspectives are either wrong or bringing a bad influence or corrupting this sort of objective system. The foundation of the system is the cultural expectation of treatment between people. And you need, I think, those different perspectives to ensure that you're defining the reasonable person, pardon the pun, in a reasonable way. And so for me, the answer is in what your definition of what the rule of law is. And for me, it is not basing it on my reaction, but assuming that in the conversation among the justices, that reaction will be considered. It will not control the outcome. I think that's what some of my colleagues were talking about when you spoke about reflection. It is not the outcome, it is the consideration in creating that legally objective, reasonable person.
Okay. Well, we are approaching the very end of this seminar. As I told you at the very beginning of this event, this is going to be a seminar series. And next year, the seminar will be hosted at Queen's University Belfast. And Chris and Alex are here because we concocted again something about the topic of next year. And so I'll leave Chris and Alex a few words to introduce what we have in mind for 2018.
Thank you, and we may be opening up a closing at the moment. So I wanted also to take the opportunity before talking about next year to thank you personally, Benedetta, for your excitement, for your enthusiasm, for your organizational skills, and for your humanity in putting this together. It's been a tremendous occasion, and I thank you personally for that. So I hope the students realize the privilege that we've had in hearing such an extraordinary panel, because, to be academic for a moment, now switching out of my practitioner hat and wearing my academic hat, we've been talking about essentially the hermeneutics of judging with those subjects that we usually examine under a microscope and who normally don't get a chance to respond and to engage. And it seems to me that what has been fascinating is the interchange at such a deep level between academic discussion, which has informed many of the questions, and the judges themselves. And I thank the judges for their willingness to become engaged in what is obviously for them, much more than for us as academics, a risky enterprise. So I thank you for taking the risk, and I thank you for your willingness to engage and to throw yourselves into the occasion. So thank you on behalf of, I hope, the audience and those of us who continue to be students and academics of your judgments. So thank you. So now to the future. So as Benedetta said, we very much hope that we'll continue this conversation, and we've already begun to think about possible types of topics. But we're at a very preliminary stage, really, in terms of identifying issues. And so I hope that those present will feel able to throw their ideas into the hat for what would be suitable issues in the future. The one that we've been tentatively thinking about is something along the lines of constitutionalism and constitutional justice in the age of Trump, Brexit, and populism. Because it seems to me that that kind of issue is one which actually affects all of the jurisdictions that are here today in different ways. And at a stage of uncertainty, because we really don't know what it's going to look like in a year's time in any of our various countries. And it's so dependent, as Rosie said, on the democratic decision-making that will occur in many of our countries over the next few years, over the next year, whether it be in the UK or in Germany or in Italy or indeed in Israel. And many other countries, Canada and the United States. Yeah.
I think you're going to find some of us, I don't speak for my entire group, a little bit more hesitant of participating as openly as we have this weekend on a topic that touches the political arena so directly.
I entirely understand.
Just as a thought in your considerations.
Absolutely. And it's exactly that sort of conversation that it would be useful to have, because there's, I hope everyone on the panel has realized that we've been as careful as we can not to embarrass or to take unnecessary risks in the discussion that we've had, and encourage a degree of openness. So it's precisely that sort of conversation that I hope we could have as to how to formulate issues in ways that can continue this conversation in the most productive way. So we're very open to that consideration. But I hope that at least there's a consensus that the conversation has been interesting and useful, and that it's worthwhile continuing it into the future. And I look forward to seeing you in one way or another in the future, and in the conversations that I hope will continue. So thank you.
Well, a very, very final word, just to thank every participant here again. Thank you very much. Thank you very much. A small token to accompany you, for those of you especially that are going to leave very soon. This is a small token of our appreciation, of our welcome, and of our gratitude, and my own personal gratitude along with that. And flowers, yeah. Just the very, very final word. This set of events wouldn't have been possible without the collaboration of a group of students who helped, organizing and managing everything. And, well, Piero Bertini, who's here, was the body and soul, along with me, of all this. So I would ask a very heartfelt round of applause for all those that weren't on the scene, but that would deserve that. Thank you very much for your attention, and, well, enjoy. Grazie. Oh, grazie.